All right, you've got a child support order in place and you think it's time to change it, but how do you know if you qualify for a modification or not? I'm Arizona lawyer Julie LaBenz, and that's exactly what I'm going to explain today. I'm going to go through what is the standard for requesting a child support modification and how to fill out the petition to do so. Now, I am in Arizona, so I'm going to be talking from an Arizona law perspective. And I'm also going to be using an Arizona court form, the petition to modify using the simplified procedure. I've been an attorney in Arizona for 20 years. I'm licensed to practice law, and this video contains legal information only. By watching this video, I don't become your lawyer. So, if you are looking to modify child support and you're looking to represent yourself, the first step is to figure out whether or not you qualify to modify. For any type of modification, whether it be parenting time, legal decision making, spousal maintenance, or child support, the baseline standard is that the person requesting the change needs to show that there's been a substantial and continuing change in circumstances. And specifically for child support, the standard for that is to show that there's a 15% change between the current amount of child support and what you believe it should be changed to. And that can be 15% more or 15% less than what is the amount in the current order. So with that said, let's look at the form. All right, so here is the Maricopa County petition to modify child support using the simplified process. So you start out by filling out your information here in the top part. And then for the case caption, you're going to keep this the same as it was in your initial either divorce or child custody establishment case. So, in other words, even if you were the respondent in your underlying divorce or child custody establishment case, and now you're the one seeking the petition to modify, you're the one filing that, you may think, oh, I'm the petitioner now. No, just like this says, in original case, you're going to keep the caption exactly the same. So if you were the respondent in the underlying divorce or in the child custody establishment, you're going to continue to list yourself as the respondent. Alternatively, if in the original case you were the petitioner, you will list your name here as the petitioner. You'll use the same case number as your original case. Okay, so now let's move down. So here you're going to give some information about the underlying child support order that you're asking the court to modify. So that could be the original child support order issued out of your divorce or child custody establishment case if it's never been changed. Alternatively, if that order has already been changed, then you are going to give information about the most recent child support order issued in your case. So you'll indicate if you're party A, meaning you're the petitioner in the original case, or if you're party B, meaning you were the respondent. You're going to indicate the order that you're wanting the court to modify. When was that issued? What was the month, day, and year? And what court? Is it still the Maricopa County Superior Court? Is it a different court? Who issued that child support order that you're wanting to change? And located in this county, so you'll name the county. If the order was not issued by an Arizona Superior Court in this county, the case has already been transferred to this county and has a Maricopa County case number. You can't just change what we call venue. You can't just change from county to county without there being an underlying order transferring your case from one county to another. So this statement right here, this is where you're making an affirmative allegation in the case that the case is in Maricopa County, either originally or pursuant to an underlying order. Achoo! Achoo! Okay, next, you're still going to be talking about the underlying child support order and who is responsible for providing medical, dental, and vision care insurance for your children. Is it the petitioner, party A, or the respondent, party B? So you'll check the boxes that apply, or that neither party was ordered to provide medical, dental, or vision insurance for your children. If you're not sure about this, you would look at your child support order and see what it says. All right, paragraph 3. The child support order currently in effect requires party A or party B to make payments of, okay, so who is the party that's obligated to pay child support? Is it the petitioner or the respondent? Check the appropriate box. And then how much are they ordered to pay? It's usually per month. So, let's say it's $250 per month payable. It's usually the first day of the month. But again, look at your underlying child support order and make sure that this information matches. All right, now you'll need to calculate child support using a child support worksheet. And this is saying that you've attached the child support worksheet to your petition and how much child support should be. So, for example, if it was $250 in the underlying order, and then you're saying it should be $500 per month according to the attached child support worksheet. I'm just using these numbers as an example. Next, you need to show that the amount you're requesting and the current amount that has been ordered by the court, that there's a 15% difference. So what you do is you take the following calculations show that a new amount varies. So first you take A, and you'll see A is defined here, the difference between the amount currently ordered and the amount requested. So using my example, the difference between the amount currently ordered, $250, and the amount requested, $500, is $250. So I put $250 here, divided by B, the amount currently ordered, $250, and then multiplied by 100. So there's your percentage change. And here in my example, it would be 100% change because 250 divided by 250 is 1. 1 times 100 is 100. Additionally, just using simple math, 250 plus 250 is 500. So that's 100% change. So you've definitely met your 15% difference standard under the numbers that I've given. But for your particular case, you're going to need to run these numbers, and you're going to need to run a child support worksheet to see what is the amount you're requesting. Now, when you're running the child support worksheet, you may say, well, I don't know my ex's exact gross income. Well, there's a couple of ways you can approach this. Number one, you can ask them to provide that. In other words, you can ask if their income has changed from the amount that was used in your underlying order. Or if you believe that their income is still the same, you can use the amount from your underlying order and then put in your changed income. But you will need to put in a number as far as gross income for each party in your proposed child support worksheet. Next is paragraph 6, is the Department of Economic Security or the Division of Child Support Enforcement providing services to at least one of the parties? You'll need to answer that question. And if yes, see the instructions regarding notice to the state in the packet. So if the Department of Economic Security or the Division of Child Support Enforcement is involved in your case, then you'll need to provide them with notice, meaning a copy of what you're filing with the court regarding this request for a modification. 7, other court-ordered payments included in the current order of assignment. So the order of assignment, this is another document related to your child support worksheet, and you'll have the date of the order of assignment. And then if spousal maintenance is included in there, you'd put the amount and how often. So $100 per month, for example. And then if there's arrears, so in other words, if the person obligated to pay child support has fallen behind in what they owe, then there can be an enforcement action that is filed, and then the court orders them to pay a certain amount, and then that amount is added in. Alternatively, arrears can accrue while a divorce or a child custody establishment case is pending, and an arrears payment can be ordered in the underlying case. But the arrears would be in the order of assignment. So if arrears have been ordered, you'd put here how much and how often. It's normally per month. And then if there's anything else that's been ordered. Relief requested, what you want this court to do. I request that child support be ordered in the amount of, in my example, it's $500 per month. You'd indicate which party you're requesting to pay that amount. Regarding insurance for the minor children, you can indicate any requests you have related to that. Now, regarding this percentage of who pays for uncovered medical expenses for your children, that is going to be in your proposed child support worksheet. In that worksheet, there's a section that gives proposed percentages for each side to pay. So you'll look to your child support worksheet and you're going to enter those percentages in here that match up with your proposed worksheet. And then if the matter goes to hearing, I further request that costs and fees incurred in bringing this action be ordered to be paid by the opposing party. Here's where you'll sign before a notary. And at that point, this petition is complete. So I'm going to stop the share from there. So once you've filled out your petition and you've got your proposed child support worksheet attached, you're going to look to file that document with the court. Now, that's not the only document that you file. There's going to be additional forms that go with the petition. And those forms are notices to the other side that tell them exactly what the next steps are. And in addition to that form that tells the other side what the next steps are, in other words, it tells them, because this is the simplified procedure. So that other form talks about whether they are going to file a request to contest, or if they're going to not contest and allow the child support modification request to go through. So there's a form about notifying them about their opportunity to object. And then in addition to that, you're also going to file a proposed child support order. And so let me show you that form as well. So here's the child support order. And again, you'll fill out all of the information. You'll indicate who has the duty to pay child support, or you'll list the two parties. You'll list the children at issue in the case and their dates of birth. You'll indicate who is ordered to pay child support, the amount you're requesting. So, just go through each section in here and start filling it out. Now you'll see here there's a difference. Let me go through this a little shorter or a little slower. So you'll check this first box. This is about what the current order says. And then this is what you're asking it to be changed to. And then you'll use this section if you're asking that the amount of child support be, if you're asking the court to deviate from the amount that's in the child support worksheet. Here's the amount of child support to be paid. There's this deviation language, reason for the deviation. This is about arrears. This is about past support, interest, and then here's the final language for the judgment. So you'd fill this out for the court, and the court can make changes to it if the court decides to do so. Obviously, the court would sign here. And then this is another option. Let's say that you and the opposing party reach an agreement. If you reach an agreement about the child support modification, you would fill out this document, and then you would fill this out, the stipulation where you both sign indicating that this is what you're in agreement to, and then the judge will review it and sign off. So that's the quickest and fastest way to proceed, is if you can reach an agreement with the other side. And I highly recommend that before or quickly after you file, you seek to engage in negotiations with the other side to see if you can reach an agreement. And then this is the information for the income withholding order. So this is where the party obligated to pay child support, this notice goes to their employers so that the child support can start being taken out of their paycheck and being sent to the person who's entitled to receive child support. So this form gets filled out and then it gets served upon the employer so that the amounts for child support start coming out of the payer's paycheck. Okay, so that's the initial step to get the case filed. Once the case is filed, from there, you're going to serve it upon the other side. Service can be through a process server, through certified mail, so long as the other side signs the green card, and then you file the signed green card with the court to show proof of service. Or there can be an acceptance of service, where the other side signs a document called acceptance of service in front of a notary, and that gets filed with the court. I recommend that you start out by trying to reach an agreement with the other side before you file. Once you file, reach out to the other side to see if they'll accept service or do the certified mailing, like give them a heads up it's coming and that they sign for it. Because it's really helpful, in my experience, for you to start the case off on a non-combative basis. And even though hiring a process server isn't a combative step, it's perceived that way because nobody likes being surprised by a process server and being served with court papers that they didn't know were coming. And so when that happens, it can often start the case off on a really contentious basis. And the way you can avoid that is through communication with the other side. I know that's not possible in every case, but I highly recommend that you give it a try in your case. Once the papers are served, the other side has, I believe, 20 days to file either a request for hearing or to do nothing. If they file the request for hearing, then the court sets a hearing date, and then the parties will appear before the court and will present their evidence about why child support should be changed, what it should be changed to, or any objections to the request being made. If the request for hearing isn't filed by the deadline, then the file goes to the judge for the judge to review everything and decide whether or not to grant the request. All right, I hope that was helpful. If you have any questions, post those down below in the comment section and I'll take a look and do my best to answer any questions in future videos. And if you're so inclined, I would appreciate if you would subscribe. And also if you give me a thumbs up, if you give me a like. So thank you so much for watching. I hope that you found this to be helpful, and I wish you luck in any request for modifying child support or any objection that you plan to make to the other side's request. All right, I'm Arizona lawyer Julie LaBenz. Thank you so much for watching.